show like the negligence and how, you know, the immediate onset of pain, the collision, all the facts of the case. So the last trial I just did, I used $47. So like it's grown exponentially, you know, over the years. It's developed. Because when I started to write this book, well, this is the second one. So when I started to write the first book, anyone who's written a book, it's brutal. I mean, the editing process. I could have wrote 10 books, you know, by the time the first book came out. So by the time the first book came out, it had evolved so much that it was almost irrelevant. So I had to write the second book, and that was, thank God for COVID, because that's when I wrote it. There's nothing going on. But, so what it's really about is about proximate cause. So proximate cause, like I said, it's very complicated unless you break it down to its bare essence. So when I try a case, and I'm going to show you how I do it, it's going to be maybe a little tough on that easel level. So what I do is I draw a lot. I draw and I write and I talk, and during trials I use videos, I use animations of surgeries. I make it entertaining for the jury. I try to keep them engaged. Because when you write, the jury's following everything you say. So in every case that I have, I tell the jury that, look, we're the plaintiff, we have the burden of proof, and we have to prove the case by a preponderance of the evidence. So unlike a criminal case like you see on TV, it's beyond a reasonable doubt, this is a different standard. And I said a really good example of it is the O.J. Simpson trial. So O.J. was tried for murder in a criminal court, and they found him not guilty beyond a reasonable doubt. But he was then sued civilly, and the standard was a preponderance of the evidence, which is more likely than not. And guess what? They said, hey, he probably killed those two people, and they found him liable. So that's typically the example I give. But I said, these are the things that I have to prove in this case. The first thing I got to prove is that the defendant was probably negligent. The second thing I have to prove is that the defendant's negligence was, again, probably approximate cause of the accident. So in the case that we're going to talk about, the defendant, my client, the plaintiff, was on her way to work in the morning. She was coming to an intersection when there was a stop sign. The defendant disregarded the stop sign, pulled out into traffic, and there was a collision. So the defendant wasn't paying attention, actually ran that stop sign. So if that defendant doesn't run that stop sign, and they stop at that stop sign, my client drives right through the intersection, and we're not even here today. So the defendant was probably negligent, and that negligence, but for, again, her disregarding the stop sign, caused the accident. So in this case, the defense, typically, if it's a rear end hit or something like that, you can get them, obviously they'll stipulate to that stuff, and you could say, I don't have to prove this, and I don't have to prove that, because the defense have admitted fault in this case. Philip, can you put up that side? So again, this is another one. Where'd that one come from? But this is the accident. So another thing that's really important, regardless of how easy or how simple the accident is, I always draw it, whether they stipulate to the negligence or not, because I want them to give it a picture. So when you talk about it, who's going to be talking about it? I go to see a lot of lawyers try cases, and some of them are really good lawyers. But I sit there and I'm like, what the hell is he talking about? He doesn't tell you anything. Like he's talking about L5S1 and C5C6, and the jury doesn't know this stuff. You got to teach it to them in your opening. So I do a really long opening, because the way I look at it, I'm going to dig that hole so deep that they'll never be able to dig themselves out of it. Because you go first. So it has a lot of, the jury's the first time they're hearing the case. So I think if I cover everything, this is what they're going to say, this is what they're going to do, evidence and testimony is going to prove this, and I go through the medicine with them, I draw the body. So this is one of the first things I do is I talk about the accident itself, and I'll draw this on the fly. slide. Is there another one? That's not the timeline one? I thought I gave you the timeline, but so I'll do it over here. So the next thing we have to show is that the defendant's negligence was of the injuries. Now, this is what the whole case is about. I tell the jury, you don't have to worry about anything else. This is the entire case. Because, and as we all know, in every single case, whether you're 13, 14, 15, 18, 25, 35, 55, 85, that it's a pre-existing or a degenerative condition that's, causing the problems with you. So, again, so this is where the domino theory comes into play. So what I do is I draw a timeline. And in this timeline, it's all about chronology, So let's say the person was born in 1964. The accident occurs in 2017. So what I do though, you have to make this relative. I'll use 5 easels, and I'll have the first 4 will be blank. And then when I get to the last one, I'll start putting these things in there. So, because think about it. You're from 1964 to 2017, this person's never had an accident. And if they have, we'll talk about that too. Never had neck pain. Never saw a doctor for neck pain. Never filed a lawsuit. I throw that one in there. Unless they did file a lawsuit, I'm gonna keep that out.
You get objections, Ed, with that?
No, not really. Sometimes, but like I said, they don't know it's coming. I'm saying it no matter what.
Right.
I don't think it's gonna get me a mistrial. I've had mistrials, but I don't think that's gonna get me one. But like I said, if there is a prior lawsuit, I'll file a motion in limine and argue that it's not coming in. Anyway, but if they haven't, I'll throw it in there. So you have all of this time, and then all of a sudden you have I call it the thin red line. Before this thin red line, everything was great. After the thin red line, not so good. So what happens is, here's the MVA, and I make these little boxes like this. She gets to goes to the emergency room, complain of neck pain, they take her out on a gurney. 2 seconds before this accident, she's driving home. Well, in this case, we'll use this one. She's driving to work. She's thinking about the things she has to do that day, and then I'm going to go home, I'm going to make dinner, we're going to do this, we're going to do that. The last thing she ever thought, 1 second before this accident, that she was going to be on a gurney, and then in the emergency room, then goes to her primary care physician, who sends her for MRIs, sends her to a chiropractor, who sends her for an EMG to a neurologist, then goes to a pain management doctor, and next thing you know, she's in a neurosurgical consult, 3, 4, 5 months later. Things that she had never ever fathomed doing. So the defense wants you to believe that somewhere along this line, the person had degenerative disc disease, and that degenerative disc disease was causing all this stuff, not the actual accident. So again, remember, what's more probable? That the accident caused all of these things, or somewhere along the line, regardless that she had never been in an accident, never had a neck pain, never went to a doctor. So, like I said, this is what I do, and if you can see, these are little dominoes. So I start to draw them, and I start introducing that concept in my opening. And then, I talk about the medicine. I said, let's talk about these injuries. And I know a lot of people can't draw, but you kind of have to suck it up and figure this out, because it's really a bunch of boxes and stuff. I mean, you should be able to do this stuff. So I tell the jury that you're going to hear a lot about medicine, and I just want to, this is what these doctors are going to testify to. That in your cervical spine, you have these blocks of bone called vertebrae. And in that area, they're called cervical that's the cervical spine. Then down in the middle here, you have the thoracic spine. And there's bones here again, and then down here you have the lumbar spine. And then a little sacrum, which is like the tailbone. So these, well, you're gonna hear a lot about discs. You're gonna hear C2-3, C5-6, but that doesn't mean there's two herniated discs. What it means is there's a disc located between the two bones, so everything's labeled. This is C2, C3, C4, C5, C6, C7. And in between all of those bones are little shock absorbers. And those shock absorbers are labeled between what they are between the two bones. This is the disc between the C2 and C3 bone. This is C5 and C4 and C5. And behind here's the brain comes down, and that's the spinal cord. And these is those bones that you feel if you run your hand down the back of your neck to pull the spinous processes. And at the level of every one of these discs, nerve roots come out, and those nerves go to your arms. And then these in the thoracic spine, those nerve roots go to your organs. And in the lumbar spine, those nerve roots go to your legs, your feet. So every one of these levels of the spine correlates with the actual part of your body. So in other words, if you go to a doctor, you're going to hear and you say, hey, I have pain, I got pain in my neck, and my ring finger, my pinky are tingling. They know already it's C6, C7. They just know that's where that dermatome goes to. So what they do is before they even send you for an MRI, they want to rule out a herniated disc, but they know where the problem is. So when they get the MRI report back, oh, C6, 7, surprise, because all this stuff works, makes sense. So, something that I think is really important is, and I take pride in this stuff. I know the medicine. Like I can cross-examine a neurologist, an orthopedic surgeon, a spine surgeon. I can do these surgeries. I mean, I've watched videos. I've reviewed everything you can. And today, it's all available. There's a lot of, when you go online, you see anything. You watch any surgery, you can, research anything. Because if you're reading a medical record, you see something, ligamentum flavum. Like you should just look it up and say, what the hell is that? So I've done that. So when you understand the medicine, I always use this argument. If me and Greg were to talk about baseball, I could argue with him on anything, because I know baseball. So when I'm going to argue with an orthopedic surgeon, I'll let him know what I'm arguing about. So I want it to be as comfortable as I am with, say, baseball that I became with the medicine. And we all know this. Every case you have, whether it's a leg or a knee or a heart or a lung or whatever, you become an expert in that body part. So you have to be able to do this stuff. Same thing. I mean, I know lawyers, they don't know anything about it. They don't even know what it means. They have no idea about the anatomy, and it's really, really important. So I do this, right? So I do this in my opening, and then when the doctor testifies, I tell him, draw the anatomy. Draws not as good as this, but he'll draw something. And then he'll show the MRI film, he'll show the sagittal film. Now it's the third time they're seeing it. So now the jury knows everything. But that's why I think it's really important. And I've had defense lawyers say, he's doing an opening. He's testifying as an expert. I'm like, no, I'm telling you, evidence testimony is going to show this thing. I'm just telling you what the doctor's going to say. This is what he's going to say. So I think this is really important, just to lay the foundation so the jury's familiar with the terminology and they can kind of jump right in. Another thing I like to do is anytime I can mimic a jury charge, I do. We have a case in New Jersey where you used to not be able to show property damage photos without an expert. Then this case came out and said, well, they can see it now, however, it's only one factor in, coming to a conclusion whether the accident caused the injuries. And that's some accidents are really, really severe and people walk away without a scratch, and some are very minor and people get seriously injured. So if I have a minimal impact case, I want that judge to read that charge as many times as he can. Anytime a photo shown, Judge, can you read the Brenneman charge? Judge, can you read the Brenneman charge? So, and I tell the judge, I said, look, the charge wouldn't exist if it wasn't true. They're showing up, and if you want if we have time at the end, I'll show you this, how I do these missed cases, how I differentiate between a human and a car. It's actually pretty effective. I've never lost on one of these cases. So, all right, so that's what I have to prove. So I go through the injuries, then I talk about the witnesses, then I talk about the diagnosis, that the whole case is about a diagnosis. And every doctor, sometimes I'll draw a puzzle and have 4 pieces of a puzzle, because they use that term a lot when they testify. So, and every defense and plaintiff, this is a diagnosis, it's a diagnosis. It's the history, onset of symptoms, it's the physical exam, and it's the diagnostic tests. You go to the doctor, what's the first thing they say? What happened? Oh, I was driving and this guy rear-ended me and my neck snapped and it started to hurt. When did it start? A minute after the accident. They send you for, they do the physical exam, they have some deficits going on, you have spasm, they send you for an MRI. The MRI is positive. Then they send you for an EMG, and EMGs are really important if you're gonna do this soft tissue spine stuff. See, an MRI, and there's a lot of literature on this, you can't look at an MRI in a vacuum and say, oh, this is caused by the accident, or it wasn't. I mean, all the literature, the New England Journal of Medicine, spine, they all say that. You can't look at an MRI in a vacuum. This is what the defense does all the time. They just look at an MRI, oh, look. I tell the jury, you're gonna see some old stuff on there, and you're gonna see some new stuff on there. When you're 50 years old, you have wear and tear on your body. And degeneration, you have to tell the jury, you gotta, embrace it. It's part of the case. You can't try not to talk about it or ignore it, because it's there. But if you think about it, what they're saying is the older you are, the more degeneration you have. So they're trying to say that the older you are, the less likely you are to get hurt, when it's the exact opposite. I tell the jury, I said, my little kids can run there, they fall down, they wipe out, they get up, they have nothing. But if my grandmother was walking around the floor and she tripped, she'd crumble into 100 pieces. So obviously you're more susceptible to injury if you have degenerative disc disease or any other wear and tear. So, whenever I have my doctors testify, I go through this. And then when the defense doctors get on there, because they'll testify to anything. And this is why it's really important that you save every report you get. Where I'm from, there's a lot of repeat offenders. There are guys that are doing 1,000 exams a year. So I was the president of NJAJ, but I'm still very involved. And I had started this thing called the 50-50 project. So I got 50 lawyers to volunteer to take a doctor, the 50 most notorious defense doctors, and each guy was responsible for getting everything on them, the reports, the death transcripts, website information, anything they could get on that guy. And then what we do is, every 2 years, we have a seminar, and we disseminate all this stuff on it. It's got, I think the last one had 40,000 pages of documents on it. It's up to 100 now, defense doctors. So, he exchanged stuff. So think about it. Because I'll subpoena every report the guy wrote, and sometimes I don't win, sometimes I do. So I have some doctors have 12,000 reports they've written. So I wheel them into the courthouse. I have them all on hand trucks. And the guy testifies, and I just start putting boxes in front of him. And now you can't see them anymore because all the boxes are covering them up. I leave a little hole so you can see them. And I say, doctor, these are the 12,000 reports you've written in the last 8 years. Would it surprise you you haven't found one person injured? No, that wouldn't surprise me. This is how arrogant they are. So I'll take out these reports, and it doesn't matter, because they're like, objection, it's a different kind of case. I said, it doesn't matter what kind of case it was. It could be a tractor trailer where the car's total, could be a fall down, could be an airplane, could be anything. It's the same opinion in every single case. And I'll say, so I'll label 100 of them. And I'll say, doctor, here's he has P22. 18-year-old girl, same opinion, right? Suffered brain strain, nothing permanent, blah, blah. 57-year-old guy, 43-year-old woman, blah, blah. It's like, you gotta get in that rhythm and just pound them into the dirt. And I say, you want me to keep going? Because I got 12,000 more. Well, you gotta admit that every one of them says the same exact thing. So if you're exchanging this information with the other lawyer, so you don't have to even subpoena it because all of you in this room have it. So if you exchange it with each other, because you could have a case where there's 4 herniated discs, and they'll say, oh, if it's multiple herniated discs, it's more likely degenerative term. No. Then I have another one that he wrote, 1 single disc, not related. And I have 100 of those, and I have 100 of those. He didn't go to the emergency room, so it couldn't have been caused by the accident. I got 500 reports he wrote where I went to the emergency room, and it's not caused by the accident. So there's so many nuggets of great stuff that you can get out of there that you're, I won't say you commit malpractice, but you have to be able to exchange this stuff. You should all be on the same team because, you know, high tide raises all the boats. And if you guys collaborate, me and my buddies, what we do is this one doctor, we're gonna take this guy out. Like, this is the worst guy of the worst, so we're gonna take this guy out. I'll schedule his deposition, then they'll schedule his deposition, then they'll schedule, like 5 of them, and we'll do 5 of them like over 5 weeks. And I'm gonna do this. Like, I dig the hole, the next guy digs it deeper, and the next guy digs it deeper. After that, they ain't testifying anymore. If I can get all your reports that you wrote and you never found anybody injured, I've gotten a lot of them. And I have someone, Tom Vesper. He got a guy down. I was trying a case in South Jersey where this guy Tom's from, that Greg knows. And he got a judge to allow him to go into the doctor's computer and pull all those reports. And this doctor kept saying that, you know, he would disagree that the 12,000 reports, he never had found anybody injured. So I had Tom in court with me. So I brought him in, I sat him in the front row. So he was gonna be my rebuttal witness. So I asked him, hey, you know Mr. Vesper? Yeah, I know Mr. Vesper, all right. The 12,000 reports, let's talk about it. And he gave it up because he knew that he was gonna come testify afterwards. That he never found anybody injured. So you have to really, if you work together, you can really, it's very effective. Now this is everything. If you talk to these old-time doctors who do defense work, they're retired, they say, 50 years ago, we didn't even need this stuff. The history is 90% of the case. 90% of the diagnosis is the history. Because they didn't have MRIs back then. They all had was a physical exam. So this is everything. So I've seen transcripts where the doctor says it, and then I bring it up to him. Hey, isn't it true 90% of the diagnosis is the history? Okay, so did you consider the history? The history is in 45 years of my life. I've never had any problems with my neck. I get rear-ended, I'm in immediate pain, I go to the emergency room, I end up getting neck surgery 3 months later. Did you take that into account? Yeah. How? Like, that's one of those ones, say, don't ask a question you don't know the answer to. I do that all the time. I'm a sinner. It's in the 10 Commandments. Don't ask a question you don't know. Like, there's no answer for it, I don't care. Like, you know, you gotta do it. Every once in a while you gotta do it. So I said, how'd you take it into consideration? Oh, I did. How? Tell me the answer. Because they don't. They just ignore it. What they do is, they ignore this, they ignore the EMG. The EMG, I gotta tell you about the EMG, how great it is. The physical exam, they do a physical exam 3.5 years later, but there's been like 30 physical exams done on this person throughout all the treatment. So he's gonna say my physical exam was negative. I said, well, this doctor's was positive, this one's was positive, this one was positive, this one was positive. They all say it's caused by the accident. You're the only one that says it isn't. How much are you getting paid? So, EMG though, what's great about the EMG is, you know, when I was telling you about you can't read an MRI in a vacuum, but an EMG, you can date a herniated disc or a nerve injury based on a herniated disc. So when you see an EMG, if you do it within 1 to 3 months of the accident, it will be an acute radiculopathy, which means it was between 1 and 3 months. If you do it between 3 and 6 months, it's subacute, which means it happened between 3 and 6 months. If you get the EMG done 6 months or more after it's chronic, then you kind of lose that dating ability because, you know, then it's chronic. Could be 6 months, could be 6 years. So if you're really on top of this stuff, like my staff, I'm like, did they get the MRI? Did they get the EMG? Did they do this? Did they do that? Did they do this? You really got to manage these cases. And look, you don't want garbage because we all know when clients are full of crap. But I don't want that. I don't want to deal with them. When I meet a client, I feel bad for them right away. I take every case. My partner's like, yo man, you're like a, what do they call me, a sailor on payday. You take everything. I said, no, but I feel bad for them, you know? So I can't help it. So that's a few of the different things that I do with these fellows. But, so, then what I do is I mention all the witnesses that are gonna testify, what they're gonna say pretty much, this doctor, that doctor, this doctor, that doctor. And I'll do things like say I have, and here's where some of my philosophies have changed. So, and I think what got me to get these big verdicts on these little, relatively small looking cases, is I would, if my client went to 11 doctors, I'm bringing 11 doctors to court. And the defense does an exam, they have one doctor, I have 11, they're like army tanks. I got 11 army tanks, how many you got? One? Bye-bye. So, you have to, make the case bigger than it is. So, the defense lawyer would call me a friend, like, who are you calling? I said, I'm calling over everybody. He said, really? Now this guy's got to cross-examine 11 doctors. That by Monday morning, the case is usually settled, but if it isn't, I'm bringing all those people in because you're more likely to win if you do that. Plus, the trial lasts for 2.5 weeks instead of 2 days, so the jury thinks it's big. However, in the last couple of years, since COVID especially, now I'm thinking the opposite. Now I'm going to make it brief. I'm going to put a doctor on for 30 minutes, get the hell out of Dodge. I'm not going to put on 11 doctors. I'm not going to bore them, because I think, we were doing virtual trials. It was like the Brady Bunch, and I have the whole jury on the screen, and I'm talking to them. I'm in my office. I'm like, this is bizarro. One lady's chopping vegetables in the kitchen. It's crazy. The one cool thing though was you could see into their houses because they were all at home. So you could kind of see what they have hanging on the walls. This one's got Jesus Christ. This one's got Babe Ruth. So you kind of tell a little bit more, I think, about the jury than if you're in a courtroom. How much time do I got?
45 minutes left.
Okay.
Yep.
So what I'll do is I'll list all the names of the doctors. Dr. Jones, Dr. Smith, Dr. Webster, Dr. E, and then Dr. Blood, the defense doctor, here. So during the trial, I'll ask the doctor, so we have to prove the case beyond more likely than not, 51% typically, right? So I'll ask the doctor to a reasonable degree of medical probability, did the accident cause the injuries? And he'll say, yeah. So, you feel any stronger than that? And some of them will say, I'm 100% certain, because all of everything lines up. So this Dr. Jones said it's 100%. So at the end of the case, I'll put in 100%. Dr. Smith, you feel any stronger than that? He'll say 95%. You might get a guy say 90%, Dr. U will say 80%. And now the defense doctor. This is where I love these guys. So in every single case, at least where I'm from, they talk about degenerative disc disease and that a significant portion of the population has pre-existing herniated discs and bulges or degenerative disc disease. So, in fact, the number they typically quote is a third of the uninjured population, from 0 to 80. So I'll say, doctor, are you saying that a third of the uninjured population has herniated discs? I'll say, yes. I'll say, so then 2/3 don't? I'm not saying that. Like, well, 1/3 does and 2/3 don't, right? So, yeah, I guess so. So this one guy wouldn't admit that 2/3 and 1/3, right? He wouldn't admit it. So I said, if I had a jar of marbles here, the jar had 67 red marbles and 33 black, what would you more likely pull out of there? Red? Like, there you go. So, if you believe him, he says it's 67% chance that the disc wasn't even there. So I said, you don't even have to deliberate, because I'm going to tell you I proved this case by 91%, including the defense doctor proved it for me, because I only have to prove it by 51%. So this is another thing that I do in my closing. I did not actually in my closing, but I elicit this information during the trial. So, and then like at the end of the case, I go back to the jury and say, remember I told you I was going to prove these things by a more likely than not standard. They admitted this, they admitted that. That did it probably cause the injuries? Well, what else could it be? I mean, it's really, there's no other explanation for it. So one day I was actually doing it was the weekend, I was closing on Monday. So I'm doing mulch around my property, I'm carrying these buckets of mulch up the hills and across the lawn. And I step on a rock and twist my ankle. And this thing blew up like a balloon, you know, I was like, oh shit, like, what am I gonna do? I gotta do this closing on Monday. So I kind of rested, so when I went into court on Monday, I was thinking about it, I'm like, you know, if I went to the doctor right now, he'd say, what happened? I'd say, I stepped on a rock, I twisted my ankle. And he would say, when did that happen? It happened yesterday. All right, let's do an x-ray. Oh, you have arthritis in your ankle, a little bit of arthritis. All right, okay. But if the doctor, you know, think about that. If he would have said to me, that's caused by the arthritis, has nothing to do with you stepping on that rock. I would punch him right in the face. So it's the same thing with an auto case or a fall down. I mean, unless they do an MRI and I got a torn ligament on my ankle, you can't say it was caused by arthritis, because everybody has arthritis, man. So you gotta really embrace that stuff. So another thing I do, and I was talking to some of you guys last night, in New Jersey, we can't ask for a number. Like, we can't ask the jury for $1 million or whatever we want. You have to leave it completely up to them. So this gets a little hairy. Because, and that's why in our state, we either have like excessive crazy verdicts or little tiny verdicts, because the jury don't know how to do this. So we can't say, ladies and gentlemen, we're looking for $1 million, and this is why, because of this injuries and this pain and suffering, all this stuff. You have to just, from the testimony of the doctors and the testimony of the plaintiff, the jury has to come up with a number on their own that will compensate them. So there are some little tricks. I do a few things. I've gotten objections here. So I'll tell the jury, say, listen, I can't give you a number, there's no chart, there's no anything, you gotta do it on yourself. However, if there was a Picasso painting in the back of that car, and it got damage, I could call 50 experts from all over the world to say it's worth 30 million, 40 million, 20 million, and I throw all these big numbers at it. But I can't tell you how much a human being is worth. I can tell you about a dumb painting. So I've gotten some objections there, but I'm not talking about them, I'm talking about the Picasso. So another thing I do is I do this, I said, look, I write help wanted. I said, there's a job. So there's a job, and the job is from July 17th of 2017 to today, February 17, 2023. This is the day I'm on trial. And this job, this is what it entails. You're gonna get rear-ended by a tractor trailer, taken away in an ambulance, be in pain the rest of your, get epidural injections, have surgery, go to physical therapy in the rain, in the snow, drive there in the summer, after work when you're tired, and I go through all these things. Like, what would that job pay? That's the verdict. So that's something I do. I also then say, now there's another job. And that job is from this job is from February 18th, 2023. And it's the person's life expectancy is 50 years, for example, to 2073. You're gonna be in pain every day, you're gonna take medication, you're gonna get older, it's gonna get worse, you're gonna have another surgery, the doctors say, What's that job's salary? And then you add the two salaries together, and that'll compensate them for the rest of their life. So that's another thing that I do. But the reason we're really here is that this is the last thing I do in my trial when I do my closing. I'm talking about proximate cause. Remember we talked about proximate cause with the timeline? So in this case, what does the defense say? That my client had degeneration, had a pre-existing condition, that was the cause of all of these problems. But what happened, we all know, was the defendant was negligent, and they admitted they were negligent. They were looking down on their seat, they weren't paying attention, they went through that stop sign and caused this collision. After the collision happened, the airbag deployed, struck my client in the face. She had the immediate onset of pain. So an ambulance came, and you could have Domino's ambulance, you could go really into depth here. You're gonna have the airbag, immediate onset of pain. They take her to the emergency room. At the emergency room, they x-ray her, say you have no fractures. Why don't you go see your primary care physician? Usually they never go, but they go to the lawyer, send it to the chiropractor. Chiropractor treats him for like 6 weeks, says, hey, we need to get you an MRI to rule out a herniated disc in your neck. So they do the MRI, the MRI is positive, says a C5-6 herniation, send it to the neurologist, and again, you can have that domino also, you can do any dominoes you want. So the EMG is positive, so we know that it's acute because the accident was less than 3 months before, so it's considered an acute finding, which dates that herniated disc, which is at the same level as the nerve impingement. So the pain continues, they send her to pain management. Pain management doctor gives her epidural injections. The epidural injections don't work, goes to an orthopedic surgeon, ends up with surgery. Like, you see where I'm going? So typically, like right now, if I get it, I'll have this table, we'll go to the end of the room, and I'll put in all these other little facts, all these little things. And you heard about that she hasn't worked since the date of the accident, and the number, I'll have the number for the lost wages. That's a number we can ask for, like medical bill or lost wage, that's an actual number. So, and then here we are today, this is the day of the trial, but we know from the testimony of the life care plan that there's future medical bills, and we know from the economist that there's future lost wages, and we know that this person can't golf anyone. This is where you put all the loss of enjoyment of life stuff. Can't golf, can't swim, can't play with their kids, but whatever those things are, you can put 100 of them. And then the life expectancy is 54.7 years, so this is gonna go on for like 54 years. So, let's find out whether or not this degeneration would have caused all of these things. If we took away the negligence, if we took away that collision, what happens to the degeneration? Nothing. You just keep on painlessly degenerating. However, that negligence did occur, and it did cause the collision, which caused the airbag to strike Ms. Jones in the face. She had the immediate onset of pain, was taken in a gurney in an ambulance, the emergency room, went to the chiropractor for 2 years. The MRI said she has a herniated disc. They tried to rule it out, but instead it ruled it in. The positive EMG, which says it was acute, which was in 3 months of the date of the EMG. The accident was 2.5 months, 2.5 months before. Went to pain management, got the epidurals. The epidurals didn't work. Went to the orthopedic surgeon. That did, got the consult. And do you think when she's driving that morning to work, 1 minute before that accident, do you think she ever had any contemplation of going for a neurosurgical consult 3 months later? It wasn't there. It's nothing. There was no evidence at all, except for some wear and tear that you see on everybody. So everybody in this room has degenerative disc disease from the time, some people in Scandinavia, they say from 13 to 18 you can start experiencing degeneration. However, so did this negligence of the defendant set in motion the sequence of events, and was it approximate cause of the injuries? You tell me. All right, thanks. If anybody has any questions on it.